The next argument is case number 18CA011443. Excuse me, Stephen Chojnacki versus Gary Mohr. Both parties are represented by counsel, so each of you will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. Just let me know and I'll keep track of that time for you. We've read the briefs and are ready to proceed if you want.
Thank you. If it may please the court, counsel, I'm Barry Wilford from Columbus on behalf of Stephen Chojnacki. I would like to reserve 4 minutes time for rebuttal.
Thank you.
Unless there are questions from the court, I'm going to confine my remarks this morning to the first argument within our single assignment of error, that being that the court below erred in failing to declare that the department's computation of Chojnacki's aggregated indefinite prison term is contrary to Ohio law. It's always good to be here, although I hope this is my final appearance in the context of this litigation. We brought this case, though, specifically here to bring the merits before you and to ask you to give rigorous examination to a case decision that for 20 years has stood without being critically assessed by other courts. The judgment of the court below relied on the reasoning of the 10th District decision in McMeans versus State Adult Parole Authority. The factual posture in that case and the legal posture in that case are identical to what is before you. And it is the argument of Stephen Chojnacki in this appeal that the reasoning of the court in McMeans should be rejected and that you should certify a conflict to the Supreme Court of Ohio, where I will rigorously defend your judgment. The decision by the Supreme Court on this question of statutory interpretation is long overdue. These issues have been bouncing around for 40 years, and the historical perspective, as we've argued in our brief, is essential to really understanding the statutory interpretation that we believe has to be given to these statutes. And I'm going to refer to 292941 as the statutory cap statute. And I will refer to 2967.13 as the minimum term statute. We've argued that the McMeans case is a faulty application of the rules of statutory interpretation. In fact, I would submit to you that it's an abomination. The primary flaw is that it fails to give statutory interpretation to both statutes. It doesn't try to interpret them in para material and give effect to both of them. What the court of McMeans did is it said both of these have to do with the parole eligibility of someone convicted and given a life sentence for this form of rape. And since both of them have to do with that, and the statutory cap statute is general, and the minimum term statute is specific, we'll go with the specific term statute. But there's no effort by the court in McMeans or any court that's touched these issues since then to really look to see can they be read in para materia. And we submit that they not only can, that they must be. The court below concluded that the parole eligibility determination of a multiple life prison term is outside the orbit of the statutory cap. I hope you will ask opposing counsel, what exactly does that mean, outside the orbit? Because the orbit of the statutory cap statute is very clear. There are 4 rules. Number 1, if there's aggravated murder among those sentences, the statutory cap doesn't apply. If there's a murder conviction and sentence among the consecutive terms, and murder carries a 15-year minimum term by itself. The statutory cap is 20 years. Rule 3, all other offenses and indefinite terms are subject to a 15-year cap. And Rule 4, that 15-year cap or 20-year cap are extended for any term of actual incarceration based on a firearm specification. And one thing that I don't think we touched on in the briefs, there are other terms of actual incarceration under the Ohio Revised Code in this pre-Senate Bill 2 law that we're dealing with here. There were for some over drug offenses, or when a judge imposed a indefinite term, they could also impose the minimum term to be so many years of actual. Well, my point being that those terms of actual incarceration, those are not exempted from the application of the statutory cap. And I submit to you that the expression term of actual incarceration, which is defined under the code, is no less suggestive of what you might infer the legislature meant when they established a term of imposing a full sentence, as they do in the minimum term statute. 10 full years for a life sentence. Full years, term of actual incarceration. I don't see really how you can distinguish the two, and it's clear that the terms of actual incarceration are not exempt from the operation of that statute. The flaw in McMeans emanates from its faulty foundation, which is a demonstrable misreading of the case law. That's the State versus Gregory decision. Like the Attorney General opinion, apologies to the Attorney General, but McMeans and the Attorney General opinion don't observe the critical fact that when that case decision was made, there was no minimum term for a life sentence for rape. So Gregory was correctly decided. McMeans says it's following Gregory, but it can't, because the postures are completely distinguishable. In one case, there was a minimum term for rape, and in McMeans, there wasn't. I'm sorry, the other way around. There wasn't in Gregory, and there was in McMeans.
Is there a minimum term for the life rape count in your client's sentence?
Yes. Yes, and there's no argument there. It was imposed before 1996, so it carried a term of 10 full years. There's no dispute about that.
Is that a term of 10 full years or 10 full years to the board?
I think the statute says the term is 10 full years. The minimum term is 10 full years with no diminishment, and this is critical because this is really what full has to do with. It's not diminished by the good time statute, the earned credit statute.
Hang on, but I want to make sure we got this. Was his sentence on that count, because we're really talking about the one count here that's at issue, 10 to life, or was it just life with an understanding that on that count it's 10 years to the board?
In the judgment, I believe it says life. Now, there's the Ohio Administrative Code regulations that were promulgated under 2967.13 that interprets that to mean 10 full years, and that means no diminishment.
10 full years until he gets his first hearing.
His eligibility on that offense, yes. In its brief, the department states Chojnacki's legal argument is without any case law support and is an overstatement I need to correct, although I readily concede we would welcome more, especially yours. When you dissect the 1986 decision in State ex rel, Gregory versus Stein, you will find that the concurring opinion of Justice Gray agreed that the minimum term statute is subject to the statutory cap statute. And therefore, we do have some judicial support. The largest irony in that case is that Gregory's mandamus action in that case was dismissed by the trial court because it was moot. Because the department had actually, after he filed the mandamus, changed his parole eligibility to give him the parole hearing after 15 years. And the Court of Appeals, for various reasons, affirmed that. So the department's kind of flip-flopped a little bit, including in Chojnacki's case, where in November, when he first went up for his parole hearing, they're showing 15 years to life as his sentence. In other words, everything's subject to the cap. But in February, when he goes back, because he has to for reschedule, then they had recomputed it. And so now it's 25 years to life. So the department has actually added to some of the confusion in this. Please,
you're at 4 minutes and 30 seconds total time here. So.
I think I'll burn up one more minute and then sit down. Please do not believe that the interplay in these statutes, one out since repealed, is somehow moot, because it's not. There are scores of offenders in prisons in Ohio serving multiple 10-year sentences, 10 full-year sentences, because they were given consecutively, and the department interprets their sentences just like they do in Chojnacki's case. Some of them have no realistic parole eligibility at all. None. Ever. And as the scholar Brian Stevenson recently observed, hopelessness is the enemy of justice.
All right, we'll have 3 minutes and 41 seconds for rebuttal. Counsel, you want 15 minutes, of course?
Thank you. Good morning, Your Honors, opposing counsel. I'm Christina Mahey from the Ohio Attorney General's Office on behalf of the defendants, and may it please the court. Before I move into my argument, I want to address the question that Judge Callahan asked about the sentence on the forcible rape under 13 count, the rape as to the appellant's daughter, because that's really the count that we're concerned with here today. His sentence in that was for life. RC 290702B holds that rape under 13 by force, that person shall be imprisoned for life. Now, there's a separate statute, 296713F, which says, he'll be eligible for parole as to that count after a full 10 years of imprisonment, but his sentence was for a term of life. I also want to address something that opposing counsel stated at the very end of his argument about the rash of people incarcerated who are facing this issue, and I just want to clarify something. The people that he is talking about who are subject to this statutory interpretation are going to be those offenders who have committed this violation, so who have been sentenced for rape under 13 that was committed by force or threat of force. So these are not all offenders who fall into this subcategory. These are, other than murderers, the people who have committed the worst offenses criminalized in the state of Ohio and in this country. So I just wanted to make that clear from the outset. So appellant's argument should fail for 3 reasons. The first is that his argument ignores the language of the statutes and statutory interpretation. The second is that it asks this court to cast aside every court decision that has touched on this issue, including a decision from this court itself. And finally, because this is not a proper Keith claim, because appellant cannot show that the adult parole authority knew or should have known that they were calculating the sentence incorrectly, and cannot show that he did not receive meaningful consideration. And so his claim should be denied on those bases. As to the first issue, the rules of statutory interpretation, both the McMeans and the Gregory court held, and this court should follow, that a specific statute governs over a general statute. And we know that as a general rule of statutory interpretation. And the specific statute in this case is 2907.02B that imposes a term of life for the offense of forcible rape under 13. That is the specific statute governing the appellant's sentence. And the more general statute is the refer to it as the CAP statute, 292941E3, that consecutive terms shall not exceed 15 years. So both the courts who have addressed this issue decided that between that general statute and the more specific statute, the specific statute must win out. Second, both Gregory and McMeans held that, and I understand opposing counsel's argument about how you don't need to apply the general versus specific criteria because you can read the statutes in pari materia with each other. Number one, I don't agree with that, but number two, even if that were correct, appellant's argument would still fail. And the Gregory and McMeans courts tell us that even if you don't engage in that analysis, 292941E just doesn't apply to this count. Because at the time appellant was sentenced, when he was sentenced to forcible rape under 13, there was no minimum term for that sentence. There was no minimum term, which takes it, and the court said, quote, outside the ambit of RC 2929.41E. And so every court which has addressed this issue has so held. This court in State v. Zedell, which appellant mentions in his brief, out of the 9th District from the year 2000, also embraced this rationale, I believe probably in dicta. But the issue in the Zedell case was the defendant was arguing that his sentence was unfair because he took a plea deal. And his argument was, if I had just pled to the indictment, my sentence would have been lesser. And the court rejected his calculation of what his sentence under the indictment would be. And specifically, the court, he was dealing with 3 different rape charges, and this is specifically what this court stated. The longest sentence Zedell could have received for any one crime was the forcible rape charge, which carries a life term with a possibility of parole after 10 years. However, if Zedell had pled guilty to all the counts, the court could have imposed consecutive sentences. Such an outcome would have resulted in Zedell not being eligible for parole for 30 years on the 3 rape charges alone. And it cites to the relevant statutes and to the McMeans decision. So this court in 2000 did embrace the McMeans decision and held that on these 3 separate forcible rape under 13 counts, the proper math was each one is capped by 2967.13 at 10 years, but those are aggregated. So for the 3 counts, it would be 3 times 10 years, so 30 years. So what the appellant asks you to do here is not only reject what your sister courts have decided, but reject what this court embraced in the Zedell decision. I do want to move on to the second prong, which is the whether or not this is a Keith's violation. I know appellant did not address that, but that is crucial because that is how he gets in front of this court, how he alleges that he has a due process violation, because we know that inmates do not have a due process right in parole. The only due process right they possess is that the information in the parole file should be correct. And the law on this specifically from Keith 1 is that the Ohio Adult Parole Authority, quote, may not rely on information that it knows or has reason to know is inaccurate. So for appellant to be successful, this court would have to hold that when the APA made their calculation, they knew or should have known it was wrong. And that cannot be so, because what are they guided by? Every single court who has addressed this issue has calculated it the way they calculated it. How is the Ohio Adult Parole Authority supposed to know better than every single court who has addressed the issue? The case law on this subject goes on that, quote, and this is from State Ex Rel. Cobb versus Ohio Adult Parole Authority, also cited in our brief, quote, the question is whether the alleged error supported by evidence may have affected the outcome of the parole hearing. And fortunately, in this case, we know the answer to that question. The information that appellant claims was inaccurate did not affect the outcome of the parole hearing. And we know that because the parole board told us why they made their decision. They did not grant appellant parole for several reasons. First, the nature of his crime, that he forcibly raped his own daughter when she was under the age of 13, and that he raped several other minors. Second, that he had not engaged in the relevant programming while in prison, And third, that he, quote, shares no remorse or insight into his actions and how this impacted his daughter and other victims, close quote. So we know the answer that the case law, we know the answer to the question that the case law asks us, which is, did this alleged factual inaccuracy affect, or was there a chance that it affected the parole decision? And we know in this case it did not. The parole board rejected him for parole based on the horrific nature of his crime and his lack of remorse. Finally, there was an argument that appellant did not make today, but that he did make in his brief regarding the Keith issue. And he argued that this has to be a Keith issue because one of the primary factors the parole board needs to look at is the seriousness of the crime. And if we don't understand what the statutory sentencing scheme is, we don't understand the seriousness of the crime. So when that 10-year minimum parole for this offense was put into statute after the offense occurred, the seriousness of the crime changed somehow, and that the court needed to take that into consideration when deciding whether or not to grant him parole. We do not agree with that argument. The Ohio Adult Parole Authority understood the seriousness of this crime. This was not a complicated crime. This was not a financial or white-collar crime that takes a great deal of legal expertise to understand. The crime here was the forcible rape of his daughter when she was under the age of 13. The Ohio Adult Parole Authority understands the seriousness of that. Everyone in this room understands the seriousness of that. And to the extent that we cannot, because we haven't undergone that kind of horror in our own lives, what will direct us to the seriousness of that crime is information such as a victim impact statement, hearing from the victim and her family. The statute here does not change the seriousness of the crime. The Ohio Adult Parole Authority understood that when they considered him for parole, and they understood that when they rejected him for parole. Because appellant has failed to meet his burden and cannot demonstrate that the Ohio Adult Parole Authority violated his due process rights, and because he cannot show that they miscalculated his parole eligibility, I would ask this court to affirm the decision of the lower court. If there are no questions for me.
Questions? Apparently there are none, so thank you very much for your argument.
Thank you very much.
Three minutes and 41 seconds remaining for rebuttal.
Thank you, Your Honor. Number one, when Stephen Chojnacki was convicted, there was a minimum term for the life sentence that he received. It was 10 full years. That piece of law was enacted in 1987, 9 years before, or 8 years before the offense was committed. Number two, the Zudell decision that counsel referred to, the decision of this court. I'm familiar with the case. Ironically, Chris Zudell is a client of mine. I've looked at that Court of Appeals decision. Chris Zudell was not sentenced to a term of life imprisonment, so it doesn't have any direct application. I don't even see why the court had to go in Judge Baird's opinion. He alludes to the fact that the life sentence in that case emanated from an offense committed in 1997. The statutory cap was repealed in 1996. All I'm saying is, and still, the court was right in that Zudell's counsel, knowing about McMeans, whether he thought it was a good opinion or not, had a legally sound basis to conclude that you could have been sentenced to more than 10 years. Number three, I don't think the test is whether the parole board knew or should have known about the mistake in the sentence. I don't even think we're talking about just the parole board here. They're the decision makers, obviously, but the department had it wrong. The department fed them incorrect information about the judgment of the court. And the parole board is required to accept that, and that provides a framework of reference for them to assess. counsel mentioned numerous times that this was the forcible rape of his daughter. That was the allegation in the indictment that he was convicted of, but Steve Chojnacki still maintains his innocence of these offenses. As far as the Keith issue, actually, I want to touch on one other point that counsel made, which is these are the worst offenses. Well, under the statutory cap, obviously that applies to murder because it says so in the statute. And I don't know if there's an argument whether a rape offense is more serious than murder, but I know this, the legislature does, and they say so in the law. So the rape offense that Steve Chojnacki was convicted of is not the most serious offense.
30 seconds.
Thank you, Your Honor. I would ask this court to reverse the judgment of the court below. I would ask you to hold that the sentence of 10 full years to life is subject to the statutory cap established in 2929.41, which is in conflict with the McLean's decision. I'd ask you to order the court below to grant equitable relief, a new parole hearing, and I'd ask you to certify this decision to the Supreme Court of Ohio. Thank you.
Thank you both. Once again, interesting arguments that we'll take under consideration, issue our decision in due course. The clerk of courts will mail each of you a copy of the decision on the day it's released, and the Supreme Court of Ohio will also post